Freedom finally arrived, or so I thought, until HOA Karen appeared on my lawn with a clipboard and measuring tape, determined to turn my dream home into a legal nightmare. After years of living under the oppressive thumb of a homeowners association where every blade of grass was scrutinized and each holiday decoration questioned, I had meticulously searched for and purchased property explicitly outside HOA jurisdiction. My new home represented liberation, a place where wind chimes could sing freely, my fence could stand proudly at my preferred height, and decorative rocks could exist without committee approval. This battle of principles began innocently enough with an official-looking letter from Margaret Blueer, a woman I recognized immediately from my old neighborhood's management board. Her reputation preceded her, a retired schoolteacher with too much time and an insatiable hunger for control, notorious for carrying a ruler in her purse to measure lawn ornaments. The letter falsely claimed my property fell under HOA oversight based on historical covenants, a complete fabrication, as my lawyer Elena would later confirm. Elena, a sharp-minded attorney with a calm demeanor that perfectly counterbalanced my growing frustration, had helped me verify during purchase that this property was gloriously, unquestionably independent. What unfolded next would become not just a defense of property rights but an absurd comedy of errors culminating in an unexpected splash, a baseless lawsuit, and justice served with a side of sweet vindication. My search for a home free from the clutches of an HOA wasn't just about buying property, it was a quest for autonomy after 5 years of living under the tyrannical regime of Oak Ridge Heights HOA. I still remember the day I received a violation notice for having wind chimes that exceeded the permitted decibel level, followed by another when my garden gnome was deemed not aesthetically aligned with community standards. Each morning began with anxiety about what infraction might be discovered next. When my realtor mentioned a charming 2-story colonial on Maple Drive that explicitly existed outside any HOA jurisdiction, I practically signed the papers on the spot. The property records clearly showed it was part of the original township development that predated the surrounding HOA communities, making it a sovereign island in a sea of regulated lawns and board-approved mailboxes. Moving day felt like a prison break. As the movers unloaded my belongings, I hung 3 wind chimes of varying sizes on the front porch, a small act of rebellion that brought me immeasurable joy. Over the next few weeks, I transformed my half-acre paradise into everything the HOA had forbidden. I installed a 6-foot privacy fence around the backyard pool instead of the previously mandated 4-foot transparent aluminum railing. My front yard featured an arrangement of decorative rocks forming a dry creek bed, something my former HOA would have required 3 committee approvals and an environmental impact study to permit. I placed Adirondack chairs painted in bright turquoise on the front lawn and added solar-powered lanterns along the walkway. The crowning glory was a handcrafted mailbox shaped like a miniature version of my house, a definite violation in my former neighborhood. Each night I'd sit on my back patio, listening to my wind chimes and savoring the sweet taste of freedom, blissfully unaware of the storm brewing just around the corner. It was exactly 28 days after moving in when I found the letter. The envelope looked official, complete with the Oak Ridge Heights HOA logo in the corner, a design I had come to dread during my previous homeownership. Inside was a 3-page document on letterhead signed by Margaret Blueer, board secretary and compliance officer. The letter began with formal language about maintaining neighborhood standards before dropping its bombshell. According to Margaret, my property was still subject to HOA regulations based on historical covenant agreements and township annexation documents from 1986. What followed was a meticulously detailed list of violations: wind chimes, unauthorized noise pollution, fence height, exceeds maximum allowed height by 24 inches, excessive decorative rock formations, requires landscape committee approval, non-standard mailbox, violation of aesthetic continuity standards, and most absurdly, unauthorized pool installation, requiring retroactive approval and safety inspection. The letter concluded with a demand to remedy all violations within 14 calendar days or face daily fines of $75 per violation. My hands were shaking, not from fear but from rage. I had specifically chosen this property to escape this exact scenario. I immediately called Elena, who had handled my closing. "Is this even possible?" I asked after explaining the situation. Elena's laugh on the other end of the phone was reassuring. "Not a chance," she said confidently. "I personally verified your property's status before closing. You're completely independent from any HOA. The 1986 document she's referencing actually explicitly excludes your lot from the Oak Ridge annexation." She advised me to ignore the letter entirely. Any attempt to engage might inadvertently give credibility to their false claims. If they persist, we'll respond formally, but for now, enjoy your wind chimes, she concluded. Taking Elena's advice, I tossed the letter into a drawer and continued with my renovations, adding solar-powered floating lights to the pool that would have certainly earned me another violation notice in my previous life. 6 days later, I was trimming hedges when a silver Lexus pulled into my driveway. Out stepped Margaret Blueer herself, clipboard in hand and measuring tape dangling from her wrist like an accessory. I recognized her immediately from HOA meetings, always perfectly coiffed with pearl earrings and a perpetual expression of disapproval. Without so much as a greeting, she marched directly to my front yard and began measuring the height of my decorative rocks. "Excuse me," I called out, setting down my hedge trimmers. "Can I help you with something?" Margaret straightened up, adjusting her designer sunglasses. "Good afternoon. I'm Margaret Blueer from the Oak Ridge Heights HOA. I sent you correspondence regarding multiple violations that require immediate attention." Her tone carried the confidence of someone who had never been questioned. "My property isn't part of Oak Ridge Heights," I replied calmly. "I checked thoroughly before purchasing. You're actually trespassing right now." Margaret scoffed, waving her clipboard dismissively. "Perhaps you misunderstood the covenant restrictions. The original developer agreement clearly states." "I didn't misunderstand anything," I interrupted, my patience evaporating in the summer heat. "My lawyer confirmed that this property is completely independent of any HOA. I have the survey and title documents to prove it." Undeterred, Margaret proceeded toward my backyard gate. "I need to document the pool fence height violations," she announced, as if I hadn't spoken at all. She unlatched the gate before I could stop her and marched toward my pool area. "This is private property," I called after her, following quickly. "You need to leave now." Margaret ignored me, methodically photographing my pool fence with her smartphone while muttering measurements into her phone's voice recorder. 6 feet, 2 inches, grossly exceeding the maximum allowed 4 feet, she noted aloud. As she stepped backward to get a better angle for another photo, she approached the pool's edge. "Margaret, watch out for that." Before I could finish my warning, she stepped too close to the edge. While trying to photograph my non-compliant pool lights, she fumbled her phone. In a move that would have been comical if not so dangerous, she lunged for the device as it arced toward the water. The momentum carried her forward, arms flailing, clipboard flying in one direction and measuring tape in another. With a substantial splash, Margaret Blueer, HOA enforcer extraordinaire, plunged fully clothed into my unauthorized pool. I didn't hesitate. Despite our confrontation, I jumped in after her, fully clothed myself. Margaret was flailing and gasping, clearly not a swimmer. I grabbed her arm and pulled her to the pool steps, helping her climb out as she coughed and sputtered. Once safely on the pool deck, rather than expressing gratitude, Margaret's face contorted with indignation. "You pushed me," she accused between coughs, water dripping from her now ruined designer outfit. "What? I was across the yard. I just pulled you out." I protested, genuinely shocked by the accusation. "I have witnesses," she insisted, though we both knew no one else was present. "I nearly drowned because of your negligence and unauthorized pool installation. You'll be hearing from my attorney. This pool is a hazard and not up to code." With those words, she gathered her soaked clipboard and limped back to her Lexus, leaving wet footprints across my patio and driveway. As she drove away, I stood dripping and dumbfounded in my yard, wondering how an act of basic human decency had transformed into a threat of litigation. Little did she know that my security cameras had captured every moment of her trespass, fall, and false accusation, a digital witness that would soon become her undoing. 7 days after the pool incident, a courier delivered a thick envelope to my door. Inside was a formal lawsuit filing naming me as defendant in Blueer vs. Homeowner. Apparently her legal team couldn't even be bothered to spell my name correctly on the initial filing. The complaint alleged negligent maintenance of premises resulting in bodily harm and near-fatal injury, along with willful disregard for community safety standards. Margaret was seeking $275,000 in damages for medical expenses, emotional distress, and remarkably, damage to professional reputation as an HOA compliance officer. The lawsuit claimed I had deliberately constructed an attractive nuisance and maliciously invited plaintiff onto premises with intent to cause harm. Reading through the legal jargon, it became clear that Margaret had concocted an entirely fictional account where I had somehow lured her to my property, verbally assaulted her, and then pushed her into my non-compliant swimming facility. I felt a peculiar mix of rage and amusement. The claims were so outlandish they bordered on comical. My first call was to Elena, who requested I send her the documents immediately. Before you worry, I told her, there's something you should know. I explained about my security system, installed after a series of package thefts in the neighborhood. For high-definition cameras with audio recording capability covered every angle of my property. The entire encounter with Margaret, from her uninvited arrival to her departure, was captured in crystal-clear detail. Send me that footage right now, Elena said, unable to hide the delight in her voice. This isn't just a dismissal, this might be sanctions territory. The video evidence was damning. It clearly showed Margaret entering my property uninvited, ignoring my multiple requests for her to leave, and then accidentally falling into the pool while taking unauthorized photographs. It also captured my immediate rescue effort and her subsequent accusation and threat. Most crucially, the audio perfectly recorded her trespassing admission when she identified herself as being from the HOA with no legal jurisdiction. Elena worked quickly, filing a motion to dismiss along with a countersuit for trespassing, filing a frivolous lawsuit, and defamation. During the discovery phase, we provided Margaret's legal team with the complete, unedited security footage. 2 days later, we received a settlement offer. They would drop the lawsuit if we dropped our countersuit. Elena advised against accepting. They've seen the video, they know they're going to lose. But the judge should see this too. The day of the hearing arrived with unexpected swiftness. The county courthouse was a stately brick building with imposing columns, a fitting venue for the absurdity about to unfold. I arrived early, dressed in my most respectable suit, and sat quietly beside Elena as we watched Margaret and her attorney enter. She wore a neck brace that hadn't been present during any previous interaction, moving with exaggerated slowness as if in tremendous pain. Our case was called third on the docket. Judge Harriet Winters, a woman in her 60s with silver-rimmed glasses and a reputation for no-nonsense efficiency, examined the filings before her. Before we proceed, she began, I've reviewed the motions and evidence submitted. Ms. Blueer, your complaint alleges this property falls under Oak Ridge Heights HOA jurisdiction. Do you have documentation supporting this claim? Margaret's attorney shuffled through papers nervously. Your Honor, we have historical covenant documents that approach with those documents, please, Judge Winters interrupted. After examining them briefly, she looked at our side. Defense? Elena stood and presented a comprehensive property survey, the original deed, and county records clearly showing my property was excluded from the HOA jurisdiction. Furthermore, Your Honor, we have video evidence showing Ms. Blueer trespassing after being informed of this fact. The courtroom's atmosphere shifted perceptibly as the bailiff set up the video equipment. As the footage began playing, Margaret's face drained of color. The video was worse than even I remembered. Her imperious attitude, dismissal of property rights, and clear trespassing were on full display. When the footage reached the pool incident, Judge Winters leaned forward, watching intently as Margaret clearly lost her balance reaching for her dropped phone, followed immediately by my rescue effort. The judge requested the video be replayed, this time focusing on the audio. Margaret's voice rang through the courtroom, I need to document the pool fence height violations, followed by my clear response, this is private property. You need to leave now. When the video concluded with Margaret's threat to sue me after I had just rescued her, murmurs rippled through the courtroom. Judge Winters removed her glasses, pinching the bridge of her nose. Ms. Blueer, am I to understand that you entered this property uninvited, against the owner's explicit requests to leave, and then sued the individual who rescued you from drowning after you fell into their pool through your own negligence? Margaret's attorney began to speak, but Margaret herself interrupted. Your Honor, the video has clearly been altered. I was invited to perform an inspection and then maliciously, that is enough, Judge Winters cut her off sharply. This court has video and audio evidence directly contradicting your sworn statement. What happened next would become legendary in local legal circles. Margaret, apparently unaccustomed to having her authority questioned, stood up and addressed the judge directly. "Do you have any idea who I am? I've been on the Oak Ridge Heights board for 15 years. I've overseen compliance for Ms. Blueer." Judge Winter's voice cracked like thunder. "You are one comment away from being held in contempt of court. Sit down immediately." The judge then proceeded to systematically dismantle the case, noting that not only was the lawsuit entirely without merit, but it appeared to be a malicious attempt to harass a homeowner who had lawfully escaped HOA jurisdiction. She dismissed Margaret's case with prejudice and found in favor of my countersuit for trespassing. The financial penalties came next. Margaret was ordered to pay all my legal fees plus damages for the frivolous lawsuit. Most satisfyingly, Judge Winters required Margaret to provide a handwritten letter of apology acknowledging her trespass and false accusations. As we gathered our materials to leave, Margaret stormed past, her neck brace mysteriously more flexible than before. "This isn't over," she hissed under her breath. Elena smiled politely. "Actually, Margaret, it is. And by the way, making threats after a court ruling is inadvisable. Those cameras I mentioned? They're also in the courthouse parking lot." The aftermath proved even more satisfying than the verdict. Within a week, the Oak Ridge Heights HOA issued a public apology clarifying that my property was indeed independent from their jurisdiction and that Margaret had acted without board authorization. 2 weeks later, a community newsletter announced Margaret's retirement from the HOA board after 15 years of dedicated service. My handwritten apology arrived exactly 30 days after the judgment, each word dripping with barely contained rage but fulfilling the legal requirement. I framed it and hung it beside my pool, next to a new sign reading "No trespassing, property not subject to HOA regulations, area under video surveillance." The following spring, I added 3 more wind chimes to my collection, painted my mailbox an even brighter shade of blue, and installed a garden gnome holding a miniature clipboard by my front walkway. Occasionally, I spot Margaret's silver Lexus driving slowly past my house, but she never stops anymore. Sometimes I wave cheerfully from my non-regulation Adirondack chair. Life outside HOA jurisdiction continues to be sweet, made all the sweeter by vindication. The security cameras that once seemed like an unnecessary expense have proven to be the best investment I've ever made, not just for package theft prevention, but for protecting against those who would trespass against both property lines and truth itself. Sometimes, those who attempt to exercise power they don't possess must face consequences they never anticipated. In Margaret's case, an unexpected swim and an expensive lesson about boundaries, both literal and figurative.